All right, well, let's go ahead and get started. Welcome, everybody, to is it June already? Oh my gosh, how is that possible? It's June. Welcome to our June meeting for the Lopardo Inn of Court. Welcome to any of our guests that are out there. We are looking forward to the fall when we can meet in person and greet you warmly, even if we do it from a distance, if we could just be in the same room with you. Uh, I think back to when the pandemic started and I started watching the musical Hamilton, and I just want I realized the resonance of I want to be in the room where it happens, because I feel like I spend all my time sitting at this space in front of a computer, not in the room where any of this happens. So I'm looking forward. I took for granted what it meant to be in a room with people and have that dynamic of conversations here and there, and being able to walk back and forth and greet people and hear something that you overhear and say, oh my gosh, yeah, that's real funny that you brought that up, or I didn't realize, where did you go? What did you do? So the exciting part, I think, is going to be when we get together in the fall. Hopefully we'll have amazing stories of what we've done and where we've gone, and maybe I'll be able to tell you how I survived the month of June and July with the courts trying to reopen, because I'm not really confident that we've developed a real strategy for how we're going to welcome people back in. We have a plan, and I've tried to consult with my colleagues about the difference between a plan and a strategy. The plan is we're going to let people in starting June 16th. That's the plan. The strategy of what they need to do hasn't been worked out. So we don't know if the public needs to wear a mask. We don't know if we need to take their temperatures, whether we're going to socially distance them. Some of that will be decided by what Cal OSHA says tonight at their meeting and what the governor says next Tuesday at his press conference. But some of that's going to depend on what you folks want to do, whether you want to come in or don't want to come in. We had a really nice meeting today where it was decided that maybe individual judges will decide whether people need to come in person or not, which I can't imagine in a county our size that we want to create 130 different rules for what each court appearance means, depending on what division you're in, what department you're in, what courthouse location you're at. But I'm looking forward to the month of June and July because it should be fun. I've already ordered my popcorn because if you got Garrett's popcorn, everything seems better. It's a personal endorsement for me to anybody that hasn't tried Garrett's popcorn for Chicago. Try it out. If you don't like it, let me know. I'll make sure to reimburse you for the cost because it's something that you're going to need to get through the next couple months with the courts. But I'm excited about what it means for us because it's another step that we're going to get back to what seems like normal, although we're never going to get back to it. It's going to be reminiscent of what we used to do. So I'm excited about what that might mean and actually seeing people besides just the court employees back in the courthouse. And so that'll be nice. I wanted to mention, we had talked previously that Dean Chemerinsky is going to be the guest speaker for the North County Bar next week. If you haven't already signed up to attend that online meeting, please do. Like I think I mentioned before, once or twice, I had a chance to meet him in person, listen to him speak at a seminar, and he makes the law seem spellbinding. He talks about cases in a way that's not quite as dry as the Rudder Group presentations that some of you might have attended, where you're like, and this is the case of so-and-so, and this happened. He actually presents as if he knows all the parties and all of the cases, and especially with Supreme Court cases, he talks as if he's personally consulted with each of the justices about why they wrote what they wrote. So it's really fascinating. He's really entertaining. So if you haven't got it, sign up for that yet, please try to, if you can. We're going to be sending out another reminder from our inn to all of our members to remind you as well, even those that didn't attend tonight, so they can do that. So with that, let me turn it over to our membership chairman, Eric Norvell. Eric, do you have any comments or?
I do. Yes. Yeah, sure. Thank you, Judge Washington. As we get toward the end of the year, as you may have seen from a few emails, it becomes necessary for us to report to national the intent of everyone to return, and it helps us to figure out where we stand with our membership. At this point, there have been 50 responses affirming return. There are a few of those that may not have responded yet. And I would ask that you send me or Bill Kamangiran an email stating your intent to return. And that way we can get a sense of where we are going into next year, so that when we all get back together, we'll actually be able to say, hey, we have 5 dozen or 6 dozen or whatever. But that's all for now. And I think I'll just pass it on back if you have anything to add.
All right, thank you so much, Eric. Let me turn next to our treasurer, Randy Ortlib. Randy, any information about what's going on with our treasury this month?
Yes, Your Honor, thank you. And I'm Randy Ortlib, treasurer. I'm smiling today because we have a year-to-date surplus of $2,800 and change, which is great. And we have reserves of over $46,000, which is great. And also, I'm optimistic about the final phase of our dues collection for the year. I'm projecting over 90% collection. And I'm working with Eric, with Bill. I've worked with Bill, and I will be working with Eric to make sure we have an accurate accounting of all of the dues paid members for this term who want to renew for next term. It's important, and it is an in policy that if you intend to renew for the upcoming year, you've got to be current on your dues from the previous term. So I'm in correspondence with members now, and by the end of the month, we'll have an up-to-date roster with everybody who intends to renew, paid up, and we're in good shape financially. So thank you, Judge Washington.
All right, thank you, Randy. And I say this every year, but some of you might not have heard it before. If you are a member, but you haven't paid your dues, and there's something going on, and certainly based on what's gone on the last 15 months, there are a whole host of things that might have impacted your ability to pay dues, but you appreciate the end, you want to be back for next year. Let Randy know, or let Bill know, or let Eric know, or let me know, because although it's a requirement that you have to have your dues paid in order to come back in the fall as a member, we'll work with you, we'll work something out, whether it's a payment plan. I know in the past, we've had members that have been gracious enough to give scholarships to members to tide them over difficult financial circumstances. So we don't want somebody to say, well, gee, I owed some money and I really love the end, but I guess I won't come back next year because I heard Randy say I have to pay my dues and I just can't do that right now. So we don't want to have you make those hard choices. So if that's your situation, understand that we'll keep your situation in strict confidence. We're not going to share it with everybody else. We're not going to announce at the next meeting. We'd like to announce the scholarships that went out to the following members. It won't be anything like that. We just want to keep you as a member of the Inn, especially if you want to be here, and we don't want our dues to be the reason why you're not participating. Likewise, if you know somebody as we roll into the fall that you think might be interested, and maybe they've expressed the same concern that, yeah, I'd like to, but that's just the expense I'm not sure I want to do right now. One, they could come as guests for no cost initially to try us out to see what they like it or not. And then again, if they decide to join, we'll work with them to make sure we set up a payment plan or otherwise take care of their finances so they can be a member. So we want to encourage, especially those of you that might know some either people that recently moved to the area, that we get a lot of great new members from folks that maybe were in other parts of the state or other parts of the country, or some new associates in your office or that you worked with or against as opposing counsel that you think, hey, you know what? They seem really nice and kind of sharp, but they could use some seasoning. Let them know about the Inn. Let them know that they can come and find out more about us. so that they can hopefully get the same benefits that all of us have received from that. So with that, I don't believe there are any other announcements outside of the group presentation, but let me just ask, I know it's really difficult because we still have all of you that are not presenters in a situation where you can't be on camera and we can't see you. But if you have any questions or concerns, as I say every month, go ahead and type them either in the chat like Phyllis did earlier or in the Q&A section, and we'll make sure those questions are asked. And with that, I'll turn it over to Team 7 for their presentation.
Great. Thank you, Judge Washington. Good evening, everyone, and welcome. I'm Larry Campitello, and the topic for tonight's presentation is maintaining a successful law practice in the shadow of the pandemic. We've all had to make changes in the way we practice law over the last 15 months. Some of the ways in which we've had to adapt have created hardship, while others have actually been beneficial. And tonight we're going to discuss those adjustments and offer insights into ways you can continue to be successful despite some lingering pandemic-related challenges. We've divided our presentation into 4 areas. First, we'll address changes in the area of alternative dispute resolution. Jim Brasher and Fred Pfister will present that portion with the assistance of seasoned mediator John Edwards. Next, we'll present some observations on changes in the courts, and that'll be handled by Bill Furman and Sage Sapahi. Then we'll hear from Darwin Bastarde, Irene Stewart, and Angela Jenkins on how the pandemic has affected dealings with clients. And finally, Anna Howard and I will provide some suggestions on how to maintain strong relationships with colleagues in a socially distant atmosphere. And with that, I'll turn it over to Jim and Fred to introduce John Edwards.
Thanks, Larry. When Fred and I got this topic for mediation in the shadow of the pandemic, we both realized pretty immediately that we shouldn't be talking. We should hand this over to John Edwards. He's a renowned mediator. He's had over 150 virtual mediations during the pandemic. During this time in the pandemic, he's a nationally recognized speaker. He's a mediation trainer. He's many years as an AV trial lawyer. He is full-time mediating cases with the West Coast Resolution Group. Both Fred and I used him. We've used him recently. John received his training at Harvard Law School. He was introduced to interest-based negotiating there, and in conjunction with, he's also trained at the Bill Eddy High Conflict Institute. And he now frequently lectures on seminars, law schools regarding high conflict personalities and how to handle those personalities in mediation. John has a deep interest in the empirical study of decision-making and bargaining, as found in the work of Nobel laureate Daniel Kahneman. And he focuses on the cognitive bias, anchoring, bargaining, and shows how the human mind makes systematic errors when making decisions in uncertain situations. John believes that those areas and that Daniel Kahneman's theories are very, very helpful and provide him invaluable assistance in helping him resolve cases without being coercive or judgmental in the process. And that is John. He is, I guess Fred and I really agree, he's a fair, calm, non-judgmental, excellent mediator. And so from there, John, I'll let you take it.
Well, thanks, Jim. Listening to all that stuff, I say, well, and sometimes all that stuff works and sometimes it doesn't. So we're here to find out what we can do to help ourselves do better during this time. Like everybody else, 15 months ago, I literally had no idea what was going to happen. I didn't even know what Zoom was. I had never done a virtual mediation. I just hadn't done it. And so the first month, every single case that we had went off calendar. And then we said, okay, what now? And we just didn't know what was going to happen. Now, I believe that there is one critical thing that occurs in a mediation that doesn't occur in other parts of the court process, and that is making a connection. I've always felt that if I can make a connection with both the lawyers that I'm working with and the clients, that I have a chance of success. And without a connection, I'm just a bump on a log. I mean, we've given you a place where maybe you can work out your case. So we need to make a connection. And so the first question that came up was, well, how do you make a connection when you're not even in the same room with the person? It's obviously a big challenge. But we had no real alternatives, so we just plunged ahead. And when Jim and I talked, a month ago, I said, well, yeah, I got 150 cases, and I got more than that now. But my view is still, it's not changing all the time, but it's evolving a little bit. And I can't look into the crystal ball and know whether or not you're going to do most of your mediations and your alternate dispute resolution virtually or in person. Only now, just this week, just like Judge Washington said, we don't even know, we have a plan, but we don't know how we're going to implement the plan. And so as it stands right now, we're going to be asking people, well, what do you want? And so I think that it's more likely than not that we will end up doing both, because a lot of people have been very, very satisfied with the Zoom mediation platform. And I'll give you one great example of why that is. We have better participation from insurance adjusters who don't care about making personal contacts with people. They don't even want to make personal contacts with people because they don't want to like the person that's in the other room, because then they might feel like they want to give them more money. And so, the essence of it is that they don't need the connection, and they're more likely to show up if they can do it by Zoom. And if they don't do it by Zoom, they don't want to come out. They don't want to fly out here from Omaha, Nebraska, or New York, or wherever, through San Francisco, or even Orange County, if they don't have to. And so this allows them to participate. And it allows a lot of people who have a problem with traveling to participate. So the idea, it's better to do it by Zoom, maybe not as good as doing it in person, but it's better to do it by Zoom than not do it at all or just phone in. And so I've come to the conclusion that there's going to be a lot of people who are going to want to keep doing it that way. And what I don't want to see, I'm sure it'll happen, but I'm a little bit reluctant to have a hybrid situation in which some of the people are in person and the other people are on Zoom. And the problem with that is I don't know that it would really affect the outcome, other than it might create a perception that it's not fair. Now, as Jim said in the introduction, I'm a firm believer that bias, it drives so many of the decisions that people make. And we just have to be aware that everybody has biases. And one of the biases that people are going to have is that Zoom mediations are good, or they're going to have a bias that they're not good. And to try to talk somebody out of it is a losing proposition. And so I don't ever want to convince somebody to do a Zoom if they want to do it in person. So my practice, and here's how are we going to implement all this? I don't know, but I'm going to ask counsel. You talk to the other counsel and see if you can decide whether or not you want to do it one way or the other. Okay, I think that would be the best approach to do it. We're either going to do them in person, or will everybody be on Zoom? And again, I'm suspecting that maybe my opinion on that will change if we end up doing hybrids and they're successful. So let's talk about some of the things that you can do to help success at the mediation. And one of them, and I think there's going to be some discussion about this later on, is that care about what you look like on camera. Now, I should talk. My background looks really busy compared to most everybody else here, but care about your lighting and your camera angles. Why do people get dressed up to go even to a mediation? We know you got to get dressed up before you go to court, because if you don't have a tie on, Judge Washington will throw you out of the court. But at a mediation, you can show up in a t-shirt if you want to, but people don't. And the reason why they don't is I'm assuming they want to be taken seriously. So why should you do it differently on camera? Now, we have toned down a little bit, and we don't, I don't have a tie on. We don't usually wear a tie. Darwin, thank you. Bill, yeah, people still wear ties because it shows respect to the process, and it shows that we're serious about what we do. Now, there's one other configuration that gives me problems, and that is when you bring your clients into the office with you and you're sharing a computer. It is a very ineffective way to make good communication with the people you're trying to communicate with. It's better if you each have your own screen, but not everybody is capable of doing that. So again, I've been very challenged with a room full of people using one computer, and I can't make a connection with any of them. I just can't do it. It's hard enough to do it the way we're doing it like this, where everybody has their own camera, their own screen. You can feel like you're speaking directly to somebody. You can even look at the camera instead of looking at the screen. And it gives the impression that you're really paying attention. Again, my goal is to make a connection. Your goal should be the same. Your goal to be an effective communicator, or else you're just going through the motions. So you need to pay attention to that. Now, there is a great big problem that has come up with doing them not in person. And that's, how do we get that magic signature on a deal if you reach a deal? And so at the start, what we were simply, okay, I want you guys to all, we'll have an honorable agreement. You all agree you've made a deal, and you'll exchange emails, and those emails will agree that we've got a deal, that each of you have the authority to bind your client to this deal. And then we cross our fingers and hope that it all works out. And just like always, it doesn't always work out. People do change their mind the next morning, and they wish they didn't do it. And somebody's going to ask them, did you sign that settlement agreement? And they're going to say, I didn't sign anything. And then they say, well, then you're not bound by that. It's gonna come up. I suppose somebody's going to run down to court and say, I want to enforce this pursuant to 664.6. And the judge is going to say, where's your signature? And they said, well, I didn't get a signature, but the other lawyer sent me an email and we agreed and everything else. And so let's not put yourself in that bind. Some mediators are going to help you, and because they'll have something for you, and others won't. So at the most fundamental level, especially if you're a defendant, you ought to think about what kind of a release you're going to want for your client to have to enter into the deal. And so with us, what we have at my group, we have the ability to take an agreement and send it out through DocuSign. Now, we're assuming, I don't know that it's ever been tested, but we're assuming that a DocuSign signature is going to be enforceable. I suppose somebody will say, hey, DocuSign, that's not the same thing, and I didn't know what I was signing, and you can't prove that I'm the one that signed it. You know, maybe that'll happen, maybe it won't, but you're a lot better off with the DocuSign agreement than not. Now, if you don't have a fully fleshed out agreement, okay, then, you know, we need to do the memorandum of understanding. And again, we send that out by DocuSign. And that's an achievable goal. And it's something that everybody should think about before they go in, because if you spend all day and hard work on a deal that then you find out that you can't enforce, that is a very unsatisfying experience. So we also realize that we have problems with timing. You know, we run out of time, and sometimes you can't get everything done in the allotted time period. That's when it's a good idea to have a good relationship with your mediator to make sure that they'll follow up and make sure that you get it done, even if you don't get it done within the confines of the hours. Now, one of the things that I've always thought was important is that, and look, I book 2 cases a day all the time. And sometimes we say, you know what, it's 1 o'clock, we got to go. Why? Because I got another case starting. If you have a choice, you want to make sure that there is more time available if you need it. So if I got a half-day case, and I'm a lawyer, I want that case to start at 9 o'clock. And I want to find out what happens if we have to go over. Do you have time? I think that's a great question to ask. And sometimes the answer will be yes, and sometimes it'll be no. If you get a yes, you've got an advantage, because you want to make sure you can seal the deal. Okay. So those are kind of my tips for right now. But remember that if your goal is to be an effective communicator, and my goal is to make a connection, pay attention, just like you would do it in person. Pay attention and make sure that you have an opportunity to speak directly with the people that you're influencing. And then I'm going to go back to rule number 1 at the start. Think long and hard about making sure that you share your briefs with the other side. Ask yourself, who are you trying to convince? The mediator or the other side? And so what good practice is giving me these days is I get the brief that they want the other side to see. And then when you want to tell me how difficult your own client is, that's the private communication you send to me. And all of that stuff that works in person, it works on Zoom. And don't send me the motion for summary judgment, and think I'm going to rule on it, okay? Because that's not what we do. So I'm not sure where we stand time-wise. Does anybody have I have a couple chats here. Let me see if I can look. Okay, no, has anybody got a chat? Anybody in the audience? Do we have some time here? I'm looking at my watch. Somebody tell me who's in charge here.
John, you're fine if I don't see any other questions or chats, so I think you're fine. Thank you.
Okay, now when I'm fine, does that mean shut up, or does that mean you got a few more minutes to kill?
No, you have a few more minutes if you like.
All right. Well, okay. So back to one more thought that I have, and that is, who is the best candidate for Zoom mediations versus in person? And again, the institutional defendant is the one who's usually very well served by the Zoom format, okay? The personal cases, the ones in which we have individual decision makers whose decisions may change on the spot. Now, the reality is most insurance defendants are going to make their decisions long before they come to the mediation, and they're not likely to change it a whole lot when they're there just because somebody has a smooth and is nice to them and makes a connection. But with individual defendants, it happens all the time. That's why we're there. And so we know that the people who have a hard time coming to the session, I'm talking about probate cases and older people, they can be so well served by Zoom, but the problem is they don't know how to use the technology and it scares them. And so if you really want to do your clients a favor and make them feel comfortable doing a Zoom, give them some time to practice. You see that people are struggling. We spend a half an hour sometimes getting them ready. We always offer somebody a test Zoom session, but hardly anybody ever takes us up on it, And so I think you as a lawyer have an obligation to your client to make sure that your client can use the technology when it's in their best interest to do so. And so, it's the people that could use it because, they shouldn't be coming downtown. They shouldn't be in a room with a bunch of other people maybe, but they don't know how to use the technology. And if they don't know how to use it, it gets in the way of the effective communication. And I know that effective communication with that type of case is often the difference between settling and not settling. Not so much with the insurance companies, but with the personal decisions that people make. If you've got a probate case and you've got siblings who have, hated each other for 40 years, and now they're trying to figure out how to divide up what, mom and dad, did, it's very, very personal. It's very intense, and they need somebody that can pay attention and listen to them. And so I urge you to think about that before you go in. And again, I'm a big fan for people who can't come downtown to do it this way. So let's see. I want my client on the same computer. I don't want you to separate us. Can I still use you as a mediator? And I do it all the time. I mean, it happens all the time, which is why I am aware that it's sometimes not the best way to do it. And so typically what I do is I say, if I want you to be separated from your client, are you okay with that? And that's a conversation that I have before we get started, okay? And if the answer is no, then no, I won't drag you away from your client. Maybe we'll speak the day before so you can tell me why you don't want your client to be separated from you. And so that's why I found that the Zoom platform with everybody on their computer, it makes it really easy for me to drag the lawyer out of the room. When I'm doing it in person and I say, I need to grab your lawyer and bring him out of the room, then all of a sudden they think there's something secret going on and maybe they don't like it. It's very seamless with Zoom. I control the button and I just pop you into a room and it's just for a few minutes. But I understand that there's times when you do not want to be separated from your client for all kinds of reasons. It's your case, not my case. I don't dictate that. I ask and you tell me what the answer is. And if I say I want to separate you and you say I don't want to be separated from my client, then you're not going to be separated from your client. Okay? Anybody else have any burning questions?
All right.
All right.
Thank you very much, John. Those are some great tips. Really appreciate it.
Yeah, it's a pleasure. It's a pleasure. I hope to see everybody around, and I assume that we will be seeing you. Randy, I expect to see you in person someday. Or did he leave us already? All right. Well, thank you guys very much for the opportunity, and best wishes. And I hope the next year is smooth. Okay.
Thank you, John.
Hey, John.
Thank you. You take care.
All right. And up next is Bill Furman and Sage Sapahi to talk about what's going on in the courts and how we can be successful going forward.
Sage, you want to get it started?
Sure. Good evening, everyone. My name is Sage Sapahi, and Bill and I are going to be presenting some of our observations in terms of how you can continue to have a successful practice during the pandemic and even more successful after the pandemic. We have broken our presentation down into 3 stages. The first is really the initiating the pleadings, filing it with the court. The second is the parties' interaction by way of case management conferences and whatnot. And then the third has to do with evidentiary hearings and trials. So we've broken our presentation with respect to that. Bill, would you like to take the lead right now, or would you like me to continue?
I'd be happy to. When you file your pleadings, you're going to find that not per se because of COVID. I think COVID essentially accelerated a lot of the electronic processes that the courts have adopted. But documents that are filed are going to come back to you conformed, and the most often reflect that they're imaged files. And importantly, when you file documents subsequently, you need to ensure that on the front of the pleadings, you insert the language that it's an imaged file on your documents. With respect to submitting documents, I expect that going forward, we're going to be using more of the electronic processes that have been adopted due to COVID and less of the attorney services. Although if you're in a rush situation, the attorney service is the better option because they can either go down to the court personally or they have a way in which to effectuate the use of the electronic services. I think most of the lawyers I interface with have been using either green filing or One Legal. I recommend that you go to either of those companies' websites. They have training available, video training facilities, so that you can become facile with using that method, unless you have a staff where you can just say, legal assistant, please take care of filing this. With regard to upcoming evidentiary hearings, where oftentimes you have to file declarations which are key for the court to make decisions, the filing deadlines are nice, but they don't work because, at least in San Diego, I have found that the court is so understaffed and not working as smoothly as they have in the past, that unless you file documents sufficiently in advance of the hearing and ensure the court has them, oftentimes the court does not have the documents you think they would have, despite your having used the reasonable filing deadline. So to that end, I recommend that you have in place a procedure whereby you have a person able to take the documents down to the court and have them delivered right to the courtroom a day or two before the court hearing, if that's what the situation demands. Because the courts are more often than not are going to essentially continue your hearing, and because of the lack of sufficient time for the courts to get through any calendar, it's going to push your hearing out to a point that's pretty uncomfortable to your client and somewhat to yourself as well. That's it that all I have to say with respect to filing of documents. Sage, if you want to pick up the short hearings part and add to anything I've said about document filing, please do.
Sure. One thing, so my practice, I represent small and mid-sized businesses up and down the state, 90% throughout in state court, 10% in district court and bankruptcy court. And during the pandemic, being a small practice, I had a couple of missteps. One of them I observed is that some specific courts now use very specific vendors to proceed with their filing. So whereas, I don't know, San Diego maybe has one legal designated, up during the pandemic, I was using, for example, one legal on a case against the city county of San Francisco. The deadline was coming up on December the 16th. I sent it up to be filed December the 15th, one day before the statute ran. It's not common practice in our firm, but the case was referred by another firm and we decided to take the case. We sent it to one legal. And at the time, during the pandemic in December, San Francisco literally had a 7 to 8 week turnaround time before you realized whether they accepted or rejected your filing. So we filed the complaint, and lo and behold, it came back rejected. So now the statute had been blown. And the sole reason had been that we had failed to check off this box on the civil case cover sheet. Well, we all know that the court can't do that. There's a specific rule of court, 3.22C, which basically says that an error with respect to the civil case cover sheet, the court has to accept it. Now, why the court in San Francisco rejected it, I don't know. So here's the lesson to be learned. I sent it back to be filed with a notice of objection to the clerk pointing this out. And then the clerk rejected it the second time saying, haha, guess what? We don't even use one legal anymore. We use, I'll never forget this, File and Serve Express, who I believe they use. So the lesson to be learned moving forward is figure out the specific vendor the court prefers. That's something I picked up on. Some of the other courts, they still have direct fax filing. I believe Riverside has it. Alameda County, I know does have it. They even have specific departments for the case management conferences. And then finally, with respect to PACER, which is what federal courts use for those practitioners in federal court, that's the public access to court electronic records. Each of that's the overall program they have, but each court has its CMF or ECF program you have to log in. And I only had one case that I can attest. It was a trademark case, and the court didn't miss any deadlines. Everything was very efficient. I found the district courts really were trying to keep everything afloat. To the extent that the parties weren't able to comply with any deadlines, we pointed out to the court, and the court punted it out with sufficient time for us to comply with those deadlines. That's what I have with respect to initiating pleadings. What else can I tell you? That's all I have with respect to the initiating pleadings.
So then with respect to short hearings, a substantial part of my practice is family law, but I also do make court appearances on general civil cases. And those are being done through MS Teams in San Diego County. I don't make often appearances in other counties, so I leave it to Sage, who does appear in other counties, to speak to that. But it runs pretty smoothly with respect to using MS Teams, and the judges go right through the calendar well. It's just when you're dealing with pro pers that the calendar stalls out completely. You've got a person in their car trying to use their cell phone, and the clerk is trying to tell them to mute or not mute, as the case may be. So that's going to have an impact going forward on whether the courts, as Judge Washington raised, whether the court's going to do a hybrid going in July, August, September, or sometime in the future. Most of my colleagues that I interface with in family court would love to continue to do short hearings through the internet. Driving down to court, parking, waiting around to have your hearing conducted, driving back just burns a lot of time that's wasted. Whereas this is pretty easy, and if you're being trailed on a case, you can be doing other work at your desk, so that's a good thing. MS Teams I find is very useful, very effective. It has more bells and whistles than does Zoom, but Zoom has beefed up what they provide. There are some tools that Sage has been using to enhance the audio and enhance the video, and I'm going to ask Sage to speak to that right now.
Sure. So one of the issues that we had early on in the pandemic is how do you interact with a client? And especially in document intensive cases, how do you interact with a client and simultaneously have them review the document. And one thing I also like to do is assess my client's credibility. A lot of times I like to hit them with records the other side is given, which are usually damaging. I like to see how they react. Sometimes I like to give it to them first time when I'm there to get their initial impression to see how they react to it. And so one of the things I found valuable is, and this was brought to my attention by a colleague, is you might have seen it, is one of these like IPVOs. You guys might not be able to see it. You might be able to see it here because I have a virtual background. But it's basically these funky little electronic cameras. They come in different sizes and they anywhere from $300 to like $800. But the good thing is that you can use them across multiple platforms, okay? You can use them in Zoom, you can use them in Microsoft Teams. And the good thing about the more advanced ones are that it enables you to split screens within the platforms. So now if you're like interacting with your client on Zoom, you can now stick under this IPVO a document and at the same time split the screen so you can have your client look at the record while you're actually talking to your client. So I found that pretty helpful, especially if you want the client to go ahead and see records and prepare it. The other thing I found out early on in the pandemic is I had an appellate hearing, and it was virtual and it was being recorded. And so I thought, oh, great! I went ahead and recorded. I did nothing with respect to my audio and whatnot. And then I got the recording back and it was really dark. The audio was all broken up. And a lesson learned was to invest in a little bit of technology, not too much. They have these little Bluetooth and whatnot microphones, which go for $100. They have little cube lights that you can attach for like another $100. And what it does is basically enables you to have sufficient lighting and audio so you can interact and hear the court better. You can hear the clients. So I found that, with a little bit of spending, $200 or $300, that enables you to have that personal contact that we were talking about earlier during the first stage, and enables you to communicate and have that much more efficiency.
I think then going to evidentiary hearings, that's something you must practice before you attempt to put on an evidentiary hearing with your client and without your client. So I recommend that you work with someone in your office or a friend to present what you want to say, how you're going to present documents, and if you have videos, how you're going to present videos. Because it can be a nightmare if you, for example, try to put on a video. And I encountered that early on in COVID. I had a domestic violence restraining order evidentiary hearing that went on for 2 days, and a piece of it was playing a iPhone video that my client had taken during the event that was one of the events that was critical to the case. And we had uploaded it and played it fine, but somehow the streaming system that I was using was not linking with MS Teams, and we had to take a recess in order to figure out what the problem was and get it working. Had I anticipated that problem would occur in advance, we would have been able to go right ahead with the hearing. Fortunately, when you've got longer evidentiary hearings, the court will give you some leeway. They're aware of the fact that this is a new era for presenting evidence. But generally speaking, the judges I have found are fine with doing visual on the internet hearings. They want to know that they can see the parties, particularly seeing your client and the other party in the case, because they're watching their demeanor, they're watching their facial expressions. So you need to tell your client that in advance of the hearing, that the judge is going to assess you personally, how you behave in the courtroom or over the internet, just as if you were standing in front of the judge 10 feet away. So prepare your client for that, and know that the judges are looking for that. Not only when the other party is testifying, the court will still be looking at your client, because that camera is going to be showing your client at the same time as someone else is speaking. So it's really no different than if you're in court and you're hearing bad evidence come in and your back is turned to your client, but your client's grimacing or making facial expressions. The court sees it and it has an impact. So be aware of that. Sage, do you want to step in and add some points?
No, following up on what you said, what I found critical with respect to the evidentiary hearings are that your clients really don't know how to set up these platforms they're going to be using. So I had a couple of cases where I was using Microsoft Teams and I carved out a Sunday afternoon to actually sit down with my clients and make sure they downloaded the program to use it. Even then, there's a significant learning curve. They're already anxious about testifying. And like Bill said, the first thing that you'll find out is especially if they're not with you in your office and they're testifying in front of their own computer or their iPad or whatnot, is they're not aware of the things that we're aware of as practitioners. So they're not aware that someone's walking in the background or their spouse is sitting next to them, whispering to them, and they're like, hey, show this, don't forget to show this. And like, meanwhile, like everything's live. So you have to have that discussion. And one of my hearings, I actually had my phone and I was texting my client. And as we were like in the hearing, he was like actually reading it. And I was like, dude, put your phone down, please. Just slide it away. Just slide it away. It looks straight up like, there's nothing else going on. So, be aware of that because the court is paying attention to those issues.
All right. Thank you, Bill and Sage. Before we move on, there was a question. Sage, can you spell the name of the split screen device?
Sure. It's called an IPEVO. It's IPEVO. I believe that's the manufacturer. It's you can buy them on eBay. You can buy them on Amazon. I got my hands on this one right before the pandemic hit. I paid a little bit more higher on eBay. Hopefully the prices have come down. This to me, single-handedly, between this and being able to get clients to electronically sign with Adobe Sign or DocuSign, those have been lifesavers for a small practitioner because literally now I can take this. And by the way, there's other technologies out there. And I'm not plugging them, but there's Esquire Tech for discovery. So if you're a small practitioner, you got hit with massive discovery, you can literally take that discovery, convert the template instantaneously and send it back and have your client respond. So there's things that we can use right now to even the playing field. But the IPEVO is the way to go, and they come in different price ranges.
Great. Thanks very much.
Sure.
All right. Let's hear from Irene, Darwin, and Angela on being successful interacting with clients.
Hi, good morning, or good afternoon, pardon me. Irene and Angela and I are going to be talking about interacting with clients and things that we've learned over the course of this whole pandemic. And so I'm going to start off by talking about the current state of COVID-19 guidelines and also raise some general ideas that a law firm may want to consider as they continue practicing in the shadow of the pandemic. So many clients of ours may expect that an attorney and their staff are going to follow COVID-19 guidelines, and many other clients are going to care less. In any case, whether we're talking about a client or an employee, the safest course of action from a liability standpoint is to follow whatever guidelines there might be. And so in that regard, as of right now today, the big guidelines that people really seem to care about have to do with masks and vaccine passports are asking about vaccine status. So right now, as of today, California says that in indoor settings, masks are still required regardless of vaccination status with some exceptions. And one of those exceptions is being a person who's fully vaccinated, being in a room full of other fully vaccinated people. Come June 15th, in just a few days, California is going to align its mask guidance to match the CDC's guidance on masks. And so what the CDC says about wearing masks is that employees should wear masks, and businesses can require customers to wear masks and can require employees to wear masks. The CDC has modified that general guidance to say that fully vaccinated people don't have to wear masks, except as required by federal, state, other local laws, and local business and workplace guidance. So basically it carved out an exception so that private employers can require their customers, their clients, and their staff to wear masks. An employer can ask about vaccine status. The law firm, I should say, can also ask their customers, ask their clients about their vaccine status. If a client says that they haven't been vaccinated, the service provider can't just flatly refuse service. The guidance says that they have to see if they can reasonably accommodate the customer. And that could take, for example, meeting outdoors or something like that. An employer can also encourage their employees, in our case, our staff, to get vaccinated. And the CDC guidelines say that if we do that, we should inform the employees of possible side effects. And the easy way to do that is to just refer them or just to look up the CDC guidelines on the topic, which are easy to find on the internet. And there's going to be a web page that lists out the available vaccinations and the side effects for each. And you would just reiterate that to the employee, or just forward them the link. So basically, the safest thing to do, again, is to just follow the guidelines as far as COVID-19 is concerned. If there is a concern about avoiding misunderstandings with your client, or obviously, from a more basic standpoint, we don't want to be the employer, or we don't want to be the attorney who gets our client sick, or at least have our employees or clients believe they got sick as a result of coming to our offices. And so some things that firms may want to do, and some things that our firm has done in light of COVID, include making sure we set up the expectations of the client in terms of what we're going to do regarding PPE or temperature screenings and things like that before the client or the employee comes in, so you can avoid some misunderstandings, and avoid some uncomfortable situations where your reception is asking the client to put a mask on or something. And so that can be pretty easy to do by giving them a heads up. If you're going to have in-person meetings or not, you should be prepared for the client to ask what you're going to do, and be prepared for the client to expect you to follow guidelines. You should also expect them to be one of the clients who don't want to do any of these things and don't want to do any PPE. So again, the idea being to have the conversation up front, or to maybe send an email up front about what may be expected of them when they come in. If, for example, again, many clients may feel like they want to start having in-person meetings. If you're still doing Zoom meetings, make sure they understand that, so they're not disappointed when it comes time to the meeting and you're reminding them when you're sending them a Zoom link. In that regard, with Zoom, we all know now that technology is making us even more available to our clients. So one thing that our firm has done is to try to manage expectations, right? We are theoretically available 24/7, but I'm sure none of us want to be available 24/7. So for our clients, in our correspondence, in our emails to our clients, we put out a little notice in our emails that basically calls out that fact that while we may be available theoretically 24/7, please don't expect us to respond immediately, and we will respond, but please know that we will respond within, fill in the blank, reasonable amount of time. Another change that our firm has experienced is that with our entity clients, we saw some of our primary contacts within our entity clients get sick with COVID or other ailments. And that kind of left us a little bit with a question mark of whether or not, of who we can be communicating with to take instructions and direction from. And so what we do now is have our entity clients, invite our entity clients to list off 1 or 2 or 3 names of people who do have authority to give us instruction should, a primary person or primary contact get sick and become unavailable. That way we're kind of covering ourselves so that there isn't going to be a later question of whether or not we're doing work that wasn't properly authorized by the appropriate person at the entity client. And kind of along that same line, firms may want to also reach out to clients and ask them for emergency contacts. As we know, people are going to get sick, and especially if they have a serious bout of something, they may not be able to return messages. And so the idea would be that you would have an emergency contact to reach out to try to reconnect with that client and learn what's going on. During COVID, none of us were seeing our clients, and getting paid became became more and more important, right? And so what our firm has decided to do was to keep credit cards on file. And so as part of doing that, we've adapted our engagement letters to to have the client sign off on the idea of giving us a credit card to leave on file, and for us to run the card after so many days after the invoice has been issued if they choose not to pay another way. And so just looking at some of the best practices in regards to that, you shouldn't be keeping the credit card information in a digital format because, as we know, digital stuff can be hacked. And so for what we do is we have a physical binder that we keep at the office that's under lock and key and only accessible to certain employees. And that's where we keep our credit card information for our clients. And so I want to close off by, kind of repeating kind of the positive thing about all of this is that because of COVID, we've been forced to adapt and to the available technology, which in turn has helped save our clients some money because we're avoiding, having to drive in person for hearing and being more available to clients because we can meet remotely. And so in closing for my part, I'll just kind of point out that there has been a recent change to the California Rules of Professional Conduct that took effect March 22, which basically adopted the ABA's stance on technology. And so the new comment says, the duties set forth in this rule, and the rule 1.1 is the duty of competency, just so you know. So a competent attorney, according to this new comment, says that the duties set forth in this rule include the duty to keep abreast of the changes in the law and its practice, including the benefits and risks associated with relevant technology. So arguably, if a old school attorney like I don't know about old school, but certainly an attorney who's afraid of change might be more comfortable telling their assistant to court call and set me up with a court call. Is that the best use of technology? No, I don't think it would be, because I think in-person, face-to-face, visual type of appearances is more effective. And not only that, it's free, right? Compared to the $90 for court calls. So theoretically speaking, the rules of professional conduct would put a duty on us to, I think, arguably use the most effective form of technology that we can. And so we should we should be aware of that. And so I'll go ahead and pass it along to Angela, who's going to talk to us a little bit more about interacting with clients during the representation.
Thank you, Darwin. Okay, so the first thing we need to do is make sure that we contact our clients and make sure they're actually okay with different forms of communication, because there's different sophistication levels between our clients. I have clients that don't even own a computer, right? So while they can't come into the office last year, they were okay with phone calls. So we need to make sure that there are certain methods of communication that they're still not okay with. If they're okay with different methods of communication, let's make sure their competence level, that they can actually communicate with us confidently. So of course, if you've got a client who regularly Zooms, they're online, it's gonna go smooth. You send the link, I don't really have to worry. It's usually best, again, to ask them ahead of time, are you okay with a Zoom meeting? If they say yes, then you go forward and you're gonna ask them, how familiar are you with this? Do you need assistance? Do you need step-by-step instructions? Try to make it as easy as possible. The other thing you can do, and I've had this with some clients, is you can get a third party in to help them, even if it's just setting up the Zoom and then leaving the room. Because you could have certain situations where having a person in the room can actually change the representation, as we know. So if the person, questions you might want to ask, is that person reasonably necessary to the client's full participation in the case? So if so, then you still have the attorney-client privilege, even though the third person stays in. If it's just to operate the technology, then the person can leave. Maybe the person actually will join via the Zoom as well and on the phone, just instructing the client, and then they can actually leave the meeting. Another issue with Zoom, and it's a plus and a minus, we have to think about any undue influence on the client. Right? So with estate planning, if you were meeting in person, you might be able to very easily tell, okay, this child is definitely instructing their parent on what to say. We need you to leave the room. If you're on the phone, you can't tell who's in the room. We don't know what's actually happening. So that's where Zoom can actually come in handy. You can tell usually just by how they're acting. Are they looking off camera? Are they asking, what am I supposed to say? What do I want? And then you can ask them, can you please show me who's in the room? Is there anyone else in the room with you? You want to make sure that your client is free of undue influence. So I kind of mentioned before that the upside of it, video conferencing, is that you can gauge your client, see if they're understanding you. Your client's gonna be a lot more relaxed when they can see you. I can't tell you how many times I hear it's nice to put a face to a name. If your clients are just communicating via phone, something can be a little bit lost there. So you have your client's gonna trust you more if they can see you. You can also share the screen, and you can review the documents with the client just as if you were there in person. And you can also, if you are doing signings and you cannot be there and there is a notary present, you can give the instructions very clearly to resume. So there's actually more of a unique aspect of Zoom, which actually has come out through this. And it's the ability to meet with disabled or non-verbal clients virtually, right? So it may have even been tricky to meet in person pre-COVID, but now we're utilizing Zoom. If you have a client with, let's say, ALS, who can only communicate using a special pad, they can very easily show that to the camera. If they're hitting buttons, I can actually hear the computer speaking to me. So those types of interactions are now available where before we might not have thought about them. So in terms of recording Zoom calls, always get your client's permission in writing. And then again on video, and that's with the California Penal Code 632. But all in all, I actually foresee Zoom meetings continuing far past this. I see that communicating with your client in different ways than purely in person and just by mail has grown exponentially. And I think it actually results in a better client-attorney relationship. I'll hand that over to Irene.
All right. Well, in the mop-up operation, I'm going to talk about video conferencing in select situations and mostly depositions and mediations. I think it's a new world and it's a wonderful world. Clients are often very hesitant and nervous about using Zoom. So I always try to be in the same room with them. But once we're in the room and I'm handling the technology for them, it goes like a dream. You get involvement, much stronger involvement from both the client and from the people on the other side in either the deposition or the mediation. The only difficulty is handling documents, and I've seen several different ways of people handling documents in these situations. One, like today, I was in a very long deposition that had close to 40 exhibits, multi-page exhibits, that the taking attorney had loaded into Dropbox and provided a link about 5 minutes before the start of the deposition. And it was highly, highly, highly annoying. But, and then would put them up on share screen, they're little teeny tiny wording documents. It was very difficult for the client. However, I've been in depositions where the attorney taking it actually prepared for the deposition days ahead of time and sent over their exhibits by email attachments a day or two ahead, printed them out, had them spread in front of the client, and they were able to read them and go through, and it went very quickly. If you put them up on Zoom, I suspect you all know now, you can actually have people annotate them through the annotation features on Zoom. So I predict it's going to go well, particularly as attorneys and clients become more and more comfortable with the processes of Zoom. The danger for clients is if they're left to the technology themselves. And what I do personal injury work and plaintiff's personal injury, And in our group, there is some attorneys, what they'll do is they'll preload an iPad with Zoom technology and a big sticky that says press here. And they ship that off to the client, and all the client has to do is press here, and they are connected to the mediation or to the deposition. This is especially useful for mediations. A colleague of mine had one in which the mediator wanted to see, for instance, accommodations that had been made in the client's home for the injuries that they had suffered. And so the client took the iPad and walked it around their house with the camera facing outward and showed all the different accommodations that had been made, and ended up with a lot more information being presented at mediation than normally would have been, in a much more graphic way, and consequently got a much nicer settlement. The questions of when it will not work, and I think that the first segment covered that nicely. It was very difficult initially in mediations to get signatures on the rough agreement, the sort of memorialization, that the settlement main points that had taken place. That's being ironed out. But for folks who have a practice like Angela's, trusts and estates, sometimes you're going to have a wet signature with a notarization. And that's still being worked out. And the whole Adobe signature issue, I'm currently in a litigation right now where somebody signed pre-COVID by DocuSign. And we're all going through the ringer right now on how to authenticate that signature to prove that she actually did sign it. So there are still many avenues, I think, to be explored for in the Zoom world, excuse me, both during and post-COVID, which I hope we're getting to very quickly. But I think on the whole, it's been a wonderful thing. And I hope that it continues in many different ways. That concludes the section on clients.
All right, thank you all. And finally, Anna and I are going to give you some brief tips on how to maintain successful relationships with colleagues. Connecting with colleagues is an important part of practicing law. Creating and maintaining friendships with other lawyers provides a social outlet and an opportunity to share experiences and knowledge with people who can relate to you on a professional level.
That's right, Larry. And I want to flag that we're right at the hour mark. So bear with us, guys. We've got about 2 paragraphs to get through. We were exploring different ideas about how to build familiarity so that we're still promoting civility, building respect amongst each other, maintaining our friendships, and keeping in mind too, that helps generate referrals, and it helps us to be acquainted with people in other practice areas.
We were actually, perhaps spoiled pre-pandemic. We're fortunate enough in North County to be able to easily interact with clients on a fairly regular basis through monthly Inns of Court chapter meetings and North County bar dinners. The beginning segment of those meetings typically offered a terrific opportunity to mingle, to catch up, to network with our colleagues, and hopefully we can return to such large in-person meetings in the not too distant future.
But until then, it's up to us to think about how to make the extra effort to stay in touch with everyone. And so we thought of 4 different methodologies that we could implement. The first is to organize and host small gatherings in an outdoor space like someone's backyard or somewhere open air like Balboa Park. We live in a gorgeous city. Let's use it.
We've also explored the idea of hosting small gatherings online. It can be difficult to have too many people in an online gathering, but maybe 5 to 8 colleagues who can participate socially and interact with one another virtually. Some examples are some kind of entertainments like whodunit sort of murder mystery that get people participating and active, perhaps a book club, a white elephant gift exchange, a scavenger hunt. There's all sorts of ways you can be creative to just invite some colleagues to participate in a social event online, stay in touch, and keep those relationships going.
We also talked about the importance of continuing with phone calls or Zoom calls to catch up with people who might be isolated, those solo practitioners, offering a virtual coffee. I've had a brunch where we all ordered food and ate together via Zoom. We talked about Wine 30, and then the old standby, my favorite, sending actual physical cards through snail mail to let people know that you're thinking about them. So that's what we got. Larry, you want to wrap it up?
Well, I'm just going to say that hopefully our in-person Inns of Court and bar events will resume very soon. But in the meantime, it's up to us to make that extra effort to maintain those important social and business relationships with our colleagues. And with that, that is the conclusion of our presentation. We thank you all for your attention, and we look forward to hopefully seeing you in person in September.
And I want to thank Team 7 for wrapping up a successful year for us. I don't think any of us were expecting when the year started that we might still be doing solely online programs all the way through the year. I think under the circumstances, everybody did a great job. I like the way your team kind of wrapped up with how we're going to maintain a successful practice in the shadow of the pandemic. I think the shadow of the pandemic is going to loom large. I said at the beginning, the court's got some concerns, and I know all of you were talking about dealing with clients, dealing with opposing counsel, dealing with colleagues. Be patient with the court. We don't have any experience dealing with this, and we don't move very quickly. We've got 130 really strong personalities that some people are, like some of you, really comfortable with technology and are going to be able to move quickly, and others not so much. And so you're going to see a lot of variation as you go from court to court in San Diego County, and certainly those of you that have practices that extend beyond San Diego County, as Sage was mentioning, because things are different up and down the state, even though we're all dealing with the same pandemic. So try to have some patience with us. If you've got great ideas that you think, gee, why is the court doing this? This doesn't make any sense. Feel free to reach out to me or any of the other judicial officers in our inn. We'll be happy to try to take that information back. It might be that we've proposed that and no one listened to us. So it might be helpful to hear from practitioners that say, this is really silly. I don't understand why we can't do this a better way. Because as I said at the beginning of this year, we're still building this plane in the air. And now we're trying to land it. And we're not sure that anybody's put all the wheels in the right places yet. So it's going to be as Judge Oxney told us today, it's going to be a bumpy ride for a bit. So hang on, bear with us. Have a great summer. I appreciate all of you so very much. I can only see Team 7 on the screen, but I know the rest of you are out there. So thank you so much for those of you that stuck with us. With that, I'm going to say goodnight to you. We'll see you hopefully in person in the fall.